We've reached the end of our lecture, and I'd like to leave you with a brief summary and to try to tie some of the doctrine together. We learned that the complicated rules of personal jurisdiction are there to protect the defendant from being brought into a court in a state that is not his own. When you see your fact pattern, focus on the defendant. Ask yourself where the defendant lives, where he works, and where the underlying facts took place. If the state of the lawsuit is not on your list, you probably have a personal jurisdiction problem. But don't stop with personal jurisdiction. Whenever you see a possible personal jurisdiction problem, train yourself to think about venue and inconvenience. If the personal jurisdiction problem is subtle and you're not sure about the answer, but ultimately conclude that there is personal jurisdiction, there will almost always be an argument that the forum is inconvenient. If your professor might not be expecting you to talk about inconvenience and will likely appreciate it if you do, particularly if it's relevant. And when you're dealing with these problems, don't let our discussion about the motion to dismiss out of your head. It is not enough to think about whether the defendant has been sued in an improper location. You also need to think about how the defendant is going to get out of that location. The answer lies in Rule 12. Remember also our discussion about the full faith and credit clause and the pitfalls that await if the defendant does not try to get out of that location properly. The Erie Doctrine ought to be on your mind whenever litigants are from several states. Remember our brief discussion on choice of law. And think about the overlap between Erie and removal jurisdiction. When a case is first brought in state court and then removed to federal court, we call that state substantive law is going to continue to apply, but federal procedural law is going to take over. We noted that distinguishing between substance and procedure can be difficult, but the good news is that it's difficult for your professor as well. So make your best argument as to whether something is substantive or procedural, and if substantive, whether there's a conflict or not, and don't sweat over it. And when thinking about multi-state disputes, never forget the requirements for diversity jurisdiction. You almost always need complete diversity and $75,001 in dispute. These are easy questions to test and easy questions to get right. When complete diversity is not present, ask yourself whether supplemental jurisdiction exists. If the case is in federal court due to a rising under jurisdiction, and the state law questions are related to the dispute, the answer is usually going to be yes. But remember that when you're trying to use joinder or intervention to add a new defendant in a diversity case, supplemental jurisdiction will usually not be available. If your professor refers to Rule 14 joinder as impleader, remember that impleader and interpleader are completely different. Do not allow yourself to be confused. Recall that the rules of discovery are broad, but also have some very stringent limitations. No will the privilege rules that we discussed. Know what to do when you don't like the jury verdict. You can ask the judge to throw out the verdict under Rule 50, or throw out the whole case under Rule 59. If that doesn't work, you can appeal, as long as you know the intricacies of the final judgment rule, that is. But you cannot relitigate. Whenever you see a fact pattern that suggests that there's going to be more than one trial on one claim or one issue, your res judicata and collateral estoppel have to go up. Make sure you know the difference between res judicata and collateral estoppel. Finally, never forget Rule 11 sanctions. While they rarely come up in real life, opportunities for sanctions can be quite common on law school exams. The sanctions rules keep attorneys in check and help to ensure the fairness of the legal system. If your question asks you to advise another attorney on a planned course of action that is just clearly wrong, bring up the possibility of sanctions. And if your question makes you the judge, and someone is clearly playing games with your court, once you conclude that the various filings are wrong for whatever reason, use the sanction rule to your advantage if you feel that you need to. I hope that my repeated discussions on fairness were helpful. And I hope that you started asking the fairness questions yourself as you were listening to my lecture. If nothing else, it should help you commit a lot of this stuff to memory. Giving this lecture has been fun for me. I hope you found it useful. Thank you for listening, and best of luck on your exam and as you embark on your legal career.